Good day, Trinidad and Tobago, the Caribbean, and the world. Welcome to another episode of Strictly Legal on WESN Content Capital. I am your host, Rondell, Donawa, attorney at law, and I'm happy once again to bring the law and you. Of course, you can stream us on WESNCC.com on all social media platforms, including our podcast, Strictly Legal with Rondell Donawa. Today, we are going to speak about whistleblowing legislation that has been in the public domain a lot of times since 2015. I know the government had tried to introduce that particular legislation. And I have a very, very noble guest, no other than Professor Rose-Marie Belle Antoine, who is a Vice-Chancellor of the Board for Graduate Studies and Research at the University of the West Indies. Before that, she had completed 2 terms as the first dean of the Faculty of Law. Why am I saying war? I know there's going to be a war soon, but no. Law, St. Augustine campus. She is a Cambridge and Oxford scholar holding a doctorate from Oxford University in offshore financial law. I know she has received numerous accolades and prizes regionally and internationally, and I know a lot of her students are locked on here today. She's joined us via Zoom. Welcome, Professor Belle Antoine.
Good morning, Sean. I'm delighted to be here once again. There are some who would say that law is equivalent to war, but I guess war is on everybody's minds today with this Ukraine issue.
I know, I'm here watching it closely, and we hope that good sense prevail.
Yep.
Yes, so thank you so much for joining me on Strictly Legal on WESN Content Capital. I know we are speaking about whistleblowing legislation, the importance of whistleblowing. Now, I note that on the 14th of January, the government once again attempted to reintroduce a new bill, which is the Whistleblower Protection Bill. But of course, if you can provide us with some context as to what exactly is whistleblowing.
Okay, so on February 4th, the bill was debated. Whistleblowing really has to do with a person who attempts to report wrongdoing in an institution. It does not have to be a workplace. Generally, we do think about it, and most laws in the world look at whistleblowing through the eyes of the workplace, but clearly it doesn't have to be. And what we know is that whistleblowing legislation attempts to protect such persons because, perhaps surprisingly to the average person, if you do the right thing without protective laws, you are likely to be subject to all kinds of penalties and sanctions because neither our existing law, nor our culture really holds up transparency or reporting as something which is laudable in the eyes of the law, in the eyes of the culture, I would argue. Being a snitch or being someone who squeals on another, even if it's for a great purpose, somehow or other, we have never gotten around to seeing that as desirable in the law. And so you need to have specific laws to protect that and to bring about a culture of transparency. And ultimately, what we are attempting to do is to prevent corruption, to prevent improper conduct at the workplace, at the institution.
And some persons, of course, I know that the opposition has really they have protested against the bill. I mean, some call it draconian. I mean, I note that you would have also produced your own expression in your commentary on the daily newspaper entitled Introducing Whistleblowing, a Timely Public Good. I mean, I know a lot of persons are thinking, okay, what's the protection against, let's say, the employer in terms of creating what you call a snitching society?
Well, I am not sure if it's accurate to say that the opposition opposed the bill. I actually read through the entire Hansard, 235 pages, and they did say on many occasions they support such legislation. But on the one hand, you say that they thought it was draconian, but there were also many instances where the opposition said it didn't go far enough in protecting the whistleblower. So it's probably somewhere in the middle. But what you ask is a good question. You ask me, well, should we be protecting the employer? And I think when I wrote in the article about a policy decision, that is really, it goes to the heart of the matter. Once you have whistleblowing legislation, just as when you take certain steps in the public interest for other areas of law, and you say, okay, in the public interest, we need to curtail certain kinds of conduct, individual conduct for the greater good. Whistleblowing falls into that category. So, what you have to do, really, what the law has to do, is to decide as a point of policy what is more important. Is it more important for us to give specific protection to someone who can come forward and tell us what is really going on so that we can fight corruption and so on? Because if we don't give that protection, it will never it will never happen. Or is it better to maintain the status quo being that the employer or the institution already has great power in terms of controlling information at the workplace, at the enterprise, and also has a law on its side, so that if they can say, okay, you are bound by confidentiality, you are bound by secrecy. You can even be prosecuted for breaching confidentiality. You can be brought before the courts for defamation once you even begin to even think about saying something and you make the first remark. So all of these things will be thrown at you, and you wouldn't get any whistleblowers coming forward. So the law has to make a policy decision. In my article, and I think it's a good analogy, I liken it to sexual harassment and sexual abuse. There was a time when it was extremely difficult. It actually still is difficult to make a case about sexual harassment and abuse because the odds are so much stacked against you, and because of this fear that suppose you accuse someone wrongfully, right? And that is true. Someone may be accused wrongfully, just as with whistleblowing, someone may be trying to just cause trouble at the workplace. Don't pretend. But if you didn't sort of reorient the law and the protection to give that protection, no one will ever come forward. No one will come forward in terms of sexual abuse. Nobody will come forward in terms of whistleblowing. So there's a conscious policy choice. And you might ask, well, all right, but how is that fair? Well, what I would say is that it's a delayed reaction by the law. So if it turns out, and this bill does do that, if it turns out that you are simply a malicious busybody, or Mako, as was said in Parliament, the law does give, after the investigation, an opportunity for that person to be prosecuted. So that's the fail-safe mechanism. And that is the sort of the formula that all over the world, after experience, because these are very difficult laws to implement, very difficult to conceptualize and implement. That is where the world thinking, the modern thinking is, that you really have to err on the side of the whistleblower protection.
And if I may just read a commentary by, I know at the second, I believe it was in the 2018 bill, which had failed. And the opposition leader at the time, Mrs. Pasabi-Sessa, had questioned the fate of confidentiality in the context of the whistleblower bill and contracts between employers and employees. And what she went on to say is that she criticized the bill as having not featured relevant changes to clauses that were considered unconstitutional, and whether or not that whistleblowing will indeed breach contractual obligations with respect to confidentiality. How do we address this?
Well, you must be able to overcome confidentiality for these purposes. In money laundering laws, for example, and again, I go back to what is your end objective? What are you trying to achieve? You're trying to adjust centuries of law and culture which says don't ever say anything. Even if you're seeing the most horrific crimes and so on, you're not expected to say anything. In the workplace, we have laws and implied contract terms that, for example, say you have a duty to confidentiality, even if it's not written down. It's part of a duty to cooperation and so on. So we've been conditioned to think you just keep your mouth shut because you're an employee. You have some sort of perverse loyalty. I call it a perverse loyalty. So, and this is how corruption thrives. So there has to be a rethinking. It is the exact same thing we have done with money laundering. And indeed, those are draconian laws in the sense that we've had to sort of curtail some rights. So it's the exact same thing that happens with money laundering. Bank secrecy, for example, which is a traditional, well-established right that we have, that has had to be curtailed in the interest of money laundering, because otherwise, how would we ever get to be able to pursue? So it's in that vein. You can't have whistleblowing laws if you allow confidentiality duties and obligations to thrive. It's just impossible. So you have to decide what is more important to your society, that you maintain individual confidentiality norms at all cost, or you say, okay, let us shape a society, let us shape an enterprise or workplace which is more informed by responsible transparency, and to put some checks and balances for those busybodies, those persons who are malicious, which incidentally, the research has shown that that is not the experience. People don't rush ahead to make false spurious claims in terms of whistleblowing. It is a very difficult thing for a person, even if they have protection in law, to come forward and say, well, I think my manager or my employer is doing something wrong, some sort of criminal. It takes a lot of courage. So it's not as though people are going to wake up every morning and say, hey, let me go and make a complaint, and I know it's not true, but let me go and accuse someone. That is false. Lots of research has actually shown that.
And what sort of evidence that one requires in order to, let's say, go to the authorities in terms of whistleblowing or reporting some sort of wrong?
That's a good question. So it's not like I feel so and so happening. You know, in the talk shows, we have a lot of talk shows because people can be anonymous, and so people will say, man, I feel so and so doing this, and or just make all kinds of claims just like that without any evidence. In whistleblowing, what we have is protected disclosures. It's a disclosure. So what is a disclosure? The concept of a disclosure has already been interpreted by law, because again, we are not reinventing the wheel. This bill is familiar. The clauses are familiar the world over. So a protected disclosure means that you would have had to have some concrete information. You may not be fully aware of the meaning of that information or how far it can get you, but you have to have found something, a piece of a document, piece of information that you got that was reported to you. It can't be that you simply on your own, as sometimes we like to do, just without any evidence, without any kind of information, document, as the case may be, make an allegation. That would not be a disclosure under the law, and it certainly wouldn't be a protected disclosure. So yes, that is a threshold, and you will have what I would call a prima facie case. You would have the investigation, and it is after that you take it from there.
Yes. Professor, indeed, this is very interesting discourse, but we have to take a break, and we'll be right back. You're watching Strictly Legal on WESN Content Capital. And welcome back. We are discussing the importance of whistleblowing with Professor Rose-Marie Belle Antoine. Before the break, I know we were discussing in terms of whether or not evidence, or what type of evidence you need to bring about a claim. Now let's go internationally, Professor Belle Antoine. I know there would have been a lot of foray relating to Julian Assange disclosure or whistleblowing with respect to, I think it was of a lot of documents or classified documents, and he was basically under the radar for for a number of years. Tell me, why was it like that, particularly in line of the fact that a lot of countries have whistleblowing legislations?
Well, and yes, and I think that sort of proves the point, because I have been with a group, a whistleblowing group. It's called All Party Parliamentary Group, and they present at the Cambridge Symposium every year. So I listen to their reports and their stories. And of course, the UK has had whistleblowing legislation for a long time. And even with the legislation, often it is the whistleblower who suffers. Even if, and there are some really heart-wrenching stories about the whistleblowers who blew the whistle about the health service and they were vilified, lost their jobs. Well, we have the Gene Miles, I think, the scenario, so we can sort of picture it.
Yeah.
And that is even with legislation. And again, that's why I was saying why it's so important for the law to be so protective. And in fact, what they're doing now in England, this all-party parliamentary group, that I'm not a part of the all-party parliamentary group, by the way. I'm part of the larger group, but
Right.
they are the ones sort of spearheading this international group of whistleblowing so-called experts, I guess. And what they're actually right now, as we speak, attempting to do is to change the UK law to make it even stronger in terms of protecting the whistleblower, because they have recognized that even with laws, and especially if you allow preliminary actions, like if you allow defamation, if you allow injunctions, all those things at the beginning, then it doesn't work effectively, and the whistleblower really has to bear too much of society's burden in trying to stamp out corruption and have transparency. And I think, Julian, I don't want to comment on whether he was noble or not noble. But even when you are doing something that is really in society's interest, it is so difficult to be protected.
Yes.
Probably the better example for us is the Jean Miles story, because we are familiar with that one from many, many years ago.
Yes.
And she lost her job, etc., etc. So you do, again, I go back to what I said in the beginning. There has to be a conscious choice. You have the public interest objective, you have the individual objectives and the rights and interests, and which do you prioritize? If you want to move forward with a society that is more democratic, that is more transparent, then you do have to curtail some of those individual interests in order to move forward.
And therefore, it boils down to the issue of constitutional rights. Everyone has a constitutional right to safety or to expression. And where does that right stop? Because we use constitutional rights a lot.
It always tends to go that. And as usual, as we've had with so many other conversations, I always say, of course, I'm a human rights advocate, but you recognize that rights are to be balanced because they are often conflicting rights. It's not just about my right. I don't have a right to do anything I want under the sun. That's not what rights are about. Rights ultimately are about trying to live in a society and ensuring that you get the greatest possible piece of the pie in terms of your rights, but ensuring that others have rights. So it's always this balance that's going on. And so this is what, once again, we are seeing with whistleblowing legislation. Does it infringe on your rights? Yes.
Yeah.
The petition is right. And I think the bill acknowledges that too. The AG read out a list of rights. It is certainly the case that some of your rights will have to be curtailed, will have to be limited for the greater the collective interests and rights. But that is not unique in our legal system. There are many instances where this is how we live in community.
Yeah. And let's look at the public. You mentioned the public interest test. Now, does that public interest test apply to private employers or private companies?
That's actually an excellent question. Yes, normally, no, the Constitution does not directly apply to the private sector. But of course, if it's legislation, the test would be different. So the test, it would simply be whether the legislation itself is infringing the rights. That is what the constitutional challenge would be. But it's not so much, if you were to just, only Jamaica in the region has changed its constitution to allow private persons to be sued directly in terms of rights as opposed to the state. But of course, that's not what we'll be doing here because it was the biggest statute itself, Parliament that will bring the statute into play and whether it can be challenged constitutionally. And the test would be, of course, is it reasonably justifiable in a democratic society? So I think that if we were to look at what is the end goal, what are we trying to achieve? The goal would be a stronger democracy because you're stamping out corruption and wrongdoing in the workplace and the enterprise and in the state companies and statutory bodies, etc. There's greater collective interest of transparency to do that. Is that reasonably justifiable? That is what the courts would have to ask. I think most people around the world today, what we've learned, what we know now, how we should proceed, the fact that there's a lot of legislation similar to this, I would suggest that the courts would say, yes, this is reasonably justifiable in a democratic society. But of course, that is a question for the courts.
And I can imagine if indeed it passes, then there will be a lot of challenges with this piece of...
I would hope not, because again, I think sometimes we lose sight of the bigger picture here. We've been saying for a long time that we do want to do these things. We want to have more procurement, better procurement laws. Why? Same reasons, stamp out corruption, so on. We've been saying we want to have whistleblowing protection. In that same debate, we talked about witness protection. This is all part of a larger social objective. So I am not too sure that we should be having all these constitutional challenges. But then, of course, what is the end game? Why? What I would hope would happen is that wherever the deficiencies in this bill, and there are some things that I think we need to look at. So, for example, I agree with the point that was made that it is probably a bit unrealistic to have every workplace with a reporting officer, a whistleblowing reporting officer. Yeah? Things like that. Maybe we should probably have more practical ways of encouraging and protecting whistleblowing, because a small workplace, that may not be feasible. These are the kinds of things that I think also questions that are raised about the whistleblowing units that are being set up under the authorities. I agree that we could look at those things again and say, okay, should we have a central authority in relation to whistleblowing, things like that? But why would we, as a society, if we say we want to move forward, if we say we believe in the objective, why would we not want to have whistleblowing legislation? What is the alternative? What other kind of legislation can we have except for protecting whistleblowers, and in protecting whistleblowers, limiting certain traditional protections in the law, so traditional interests in the law and traditional rights? So either we want it or we don't want it. So if we don't want it, sure, challenge it constitutionally. But if we say we do want to have it, and I don't think that is the way forward, I humbly suggest.
Yes.
What I would say is that we should work together, all parties, as we're doing in other countries, all party groups, and try to get the best formula, because it is not easy legislation to implement.
Especially with a society, you also have to look at the diversity and the cultural norms and everything of our society as well.
Well, yes, although I have also argued, perhaps a bit tongue-in-cheek, that this is one of those cases where we don't want to accommodate culture too much. What we really want to do is shape culture. And again, I'm sometimes a little perplexed. On the one hand, we say, well, we are a culture of macos. We like to mind people's business and gossip. Okay, so if that is on the other hand, we say nobody says anything when something goes wrong. Nobody wants to come forward. It can't be both. It's either one or the other.
Correct.
But ultimately, what I do think legislation like this should do and will do, and this doesn't happen overnight, it's incremental, it is to shape a different kind of culture of responsibility, corporate responsibility, individual responsibility, transparency, looking after your neighbors, being your neighbor's keeper, probably identifying better what corruption is, because I think we have a warped sense of what corruption is in this country.
Yes.
We think corruption is only about putting your hand in the till and pulling out money. No, it's a lot broader. So I think it can sensitize and make people more aware. But obviously there needs to be a lot of education
Indeed,
about this kind of law.
Indeed. And do you agree with the term, this is a political witch hunt bill? I know that has been...
I sort of ignore and put aside both sides of the political arguments.
Yes.
Both the reasons why people didn't want the bill and people why they were putting the bill forward. None of that made any sense to me on either side, and I'm not into those arguments. None of it, as I said, made any sense to me.
Yeah.
So what I think we should be focusing on is, I would say, go forward in goodwill on both sides. If both sides say, we agree, and I have heard both sides say it, sometimes they contradict themselves, but I've heard it, that we think this is important legislation. We need something like this. Incidentally, we have signed a convention on corruption, and this is all part of that whole milieu. So we want to do it. We want to do things like procurement legislation or better procurement legislation, because we have some. We want to have things like, campaign finance.
Campaign finance. That's
if we all agree we want to do it, so all of us are saying we want to do it, so let's forget, I'm not a politician, I'm a little academic and attorney and stuff like that. So let us work towards it. And there's enough, I think there were some good arguments made both sides. And if we can sit down, and we've been doing it and trying to do it a long time, but again, let us not be too hard on each other. This is not simple legislation. I think you referred to my article.
Yes.
I did say it's not going to be perfect, because all of the countries are grappling with what is the best way. UK, as I said, is about to change quite a few things. In fact, they liked some of the provisions that we have put in here. They thought it was broader, the concept of protected disclosure. So, it's all a learning curve. Let us sit down, if we are really serious about the objective, and see, what your idea is a good one. No, I don't agree with this, but this might be workable. We can do that. We can work together, man. Let's do it.
Yes, for a better Trinidad and Tobago at the end of the day, regardless of affiliates.
Of course, Rondell, of course.
Yes,
I'm sorry for calling you Sean. It's
That's
just,
okay.
I know he's your producer.
Thank you so much.
Yeah, we can do it, man.
Yes, we can.
At some point, we're going to grow up. We're almost 60 years independence soon. Come on.
Yes,
we can do this now.
Yeah. Put aside all bipartisan, as we call it.
Yes.
So, Professor, thank you so much for joining us. I know this is a conversation that can go on and on. Maybe once you're available again, we can come back on and discuss more.
Well, I think let us hope we pass the bill. And as I said, there needs to be education after that. So there's a lot to do in this area. So let's just pray that there's a good outcome.
Yes. So thank you very much.
Thank you so much for inviting me.
Indeed.
Have a great day and stay safe.
You too. So guys, you have been watching Strictly Legal, the importance of whistleblowing with Professor Rose-Marie Belle Antoine of the University of the West Indies. Join us once again for another episode next week. Be safe. God bless.